I function of during the after death, there is actually 20 days interim bail. This gives the mother's pension. Pension is required to file an affidavit and a death certificate. Yes, next. Sure, permission. I have filed application but with jail criminal 15th of 2013. He is in jail process since around 15 years. Monday. My lord, 10 years about my lord. It is in custody, my lord. Give it.
Supplemental list, item number 1.
No, appearing conditional location 3025 is my law. Imprisonment for life with 5,10,000 rupees.
As made with the trial court interim applications for bail and steel considered as per receipt of the trial. In the meantime, the learning council for the appellants have supplied the deposition published to the learning council for this purpose.
Item 2.
My lord, they were 15 of February week because against two orders of the two original applications by a common judgment, my lord, both the ways have been disposed of.
Yes.
So, my lord, one writ application is filed against OA number 212 and another is ready, my lord, but it is not filed. Therefore, I am paying for some time. Both the matters can be handled.
Mr. Mishra 6 for an adjournment 2 weeks after. Yes.
Okay.
Item 3.
In this case, my lord, I am appealing for opposite party. Where is the petitioner?
Yeah.
Petitioner is the Union of India.
Yes, sir.
All the next item.
Also,
Item 4.
also.
Yes, item 4, Mr. Balaji.
But this petition is filed, to implement the order of the London magistrate, which is the second part of the section 14. The first part says about the passing of the order within 60 days. The provision is complete, when this is implemented. So,
What is the order?
The order is appointed the advocate commissioner to execute that order.
Where is that order?
That order is there at page 14. That was 3rd of January 2024.
Surface Act.
Section 14 Surface Act.
What order has been passed finally?
Well, finally, the officer appointed to take possession of the property. So that is not happening. 3 issues I have raised here. The first is the timeline to implement this order.
Read which part of the order, let us see.
Yes. Page 18, if your lordship may.
Yes.
Page 17 rather, sorry. Yes. Later, this is 13th February 2024 order. The case record put off since advocate so-and-so in enrollment so-and-so file a self-attested copy of enrollment certificate.
Where are you reading? Where are you reading?
Operative part.
Page 17.
17, which part?
Last part, letter. Order dated 13/2/2024.
The case record is put up.
Yes, ma'am.
Since the advocate.
The advocate is the advocate commissioner appointed by the London magistrate. There is subordinate officer. Along with the written consent to act as subordinate officer in this case, accordingly, Mr. Sahoo, being enrollment number so-and-so, having mobile number so-and-so, is appointed subordinate officer to take possession of the secured assets specified in the body of the miscellaneous application and to forward the same to the secured creditor. For securing
Who are you in this transaction? You are the...
I am the secured creditor.
Secured creditor.
I am the secured creditor. My lord, in my favor, the order was passed.
Yeah.
And
What is the
thereafter,
problem?
my lord,
Who is not executing?
so that is what the
DCP Cuttack and IAC local self
they are
assistant.
not executing. You know, the contention what I have raised, as per the 14, they did. So the provision says the duty is cast upon the London magistrate to complete that order, to execute, to take possession and hand over to the
So
security. Now, you may kindly see the provision itself.
What is the purpose of it?
But if this is an intermediary stage.
Not yet.
He's in the process of doing it. See, when the order was passed,
The order was passed,
February 24.
yes.
And have you again went to the magistrate saying that, see, you have to complete it? Straight away you came to this High Court.
No. Thereafter, the order was challenged before this honorable court. This honorable court said that you deposit some 12 lakhs. He did not deposit. Then he filed a recall application before the London magistrate. The London magistrate stayed that order.
So it's a 24 order.
24.
What happened thereafter?
Thereafter, he approached this honorable court.
Who approached this?
The borrower approached the honorable court.
Yeah.
That is at stage,
What is the fine of the, now what is the stage?
now the stage is that he did not comply with that order. Rather, he filed a recall application before the magistrate. That was dismissed. So finally, the order is upheld.
Which is the final order?
This final order is upheld by the London magistrate.
What is that?
I remember that was the This is the 25th March 2025 order.
Twenty-five, 3/2025.
Order. This is finally disposed of. Recall application was dismissed. Recall application filed by the
Why have you not
borrower.
annexed it?
No, I have taken the plea.
File. The land council for the petitioner wants adjournment to file some orders out of this matter after we commencing from 1st September.
And give a sequence of event also.
Yeah.
That's the.
Next.
Item 5.
Hello.
File a detailed chart indicating the sequence of events.
Sequence of event,
Yes.
including this date, last date.
Yes, next.
Item 5.
In this case, the petitioner is challenging the inaction of the opposite parties in publishing supplemental result due to resultant vacancy in the order of London Tribunal dated 1/8/2025 and dismissed the way without application of mild manner. Non-application of mild manner, completely non-application of mild order 1/8/2025.
What was your prayer?
Prayer for passing of order dated 1/8/2025 manner passed by London Tribunal.
No, before tribunal, what was the order? Where is the way?
Manner.
Where is the
Way order manner. Way.
no, way?
Original application.
Space manner 26 minutes.
Come to your relief short for, let us see.
Manner. Hello. The surplus result of limited departmental competitive examination LDC for recruitment to the cadre of postman, mailguard and multitasking staff MTS from the Gramin Dak Sevaks. Candidates for resultant vacancy arises from the departmental promotion in postal assistant PA, cutting assistant SA pursuant to declaration of result of PASA on 27/3/2025. Be published within a stipulated period of time.
That was not published.
No, ma'am.
So why, what order was passed by the tribunal?
Tribunal minor. May I explain just in
No,
1
no,
minute?
you say that the declaration of result the
Madam.
surplus result of so and so for recruitment to the cadre of so and so or result and vacancy arises from departmental promotion.
It's a small chat manner.
Really, all confusion.
Minor.
Come to 146, page 146,
Ma'am.
impugn order, para 6, read it.
We have examined the case of applicants with reference to the arguments and pleadings.
Aram se, slowly,
Pleadings
along with materials placed in support thereof. Even according to the own admission of applicants, the result of recruitment PASA were declared on 27th 2025, and thereafter promotion was effected from the cadre of postman, mail guard, and MTS. Thus, obviously and axiomatically, vacancies in the grade of postman, mail guard, and MTS has arisen in 2025, only after their promotion to PASA. As such, the said vacancies in the grade of postman, mail guard, MTS cannot be said to be a vacancies of 2024. The wholesome stand of the applicant is that since the notification was dated 12/6/2024 for filling of the vacancies of 20 PASA against vacancies year 2024, the resultant vacancies to be created in the cadre of postman, mail guard, and MTS upon their promotion is to be taken as the vacancy of 2024. This logic is not supported by any provision of rules or law. Rather, right is the position of that it is the year of recruitment in which the vacancy occurred would be relevant date, and that if the vacancy caused for any reason after the selected candidates appointed against available vacancies, it gives rise to a fresh vacancy which could not have been filled up without issuing a proper advertisement, and following the fresh selection process is settled with the position of law by Sudesh Kumar Goyal versus the state of Haryana. Civil appeal number 10861 of 2013, declared 21/9/2020. Further, it is a settled legal proposition that vacancies cannot be filled up over and above the number of vacancies advertised as the recruitment of the vacancies in candidates in excess of the notified vacancies is a general and deprivation of the constitutional rights under the Article 14, read with 16(1) of the Constitution. Of those persons who acquired eligibility for the post in question in accordance with statutory rules subsequent to the date of notification of vacancies, filling of the vacancy over the notified vacancies is neither permissible nor desirable, for the reason that it amounts to improper exercise of power, and only in a rare and exceptional circumstance and in emergent situation such a rule can be deviated from, and such a deviation is permissible only after adopting policy decision based on some rationale. Otherwise, the exercise would be arbitrary. Filling of vacancies over the notified vacancies amounts to filling of future vacancies. Thus, it is not permissible in law. Cited judgments, my lord.
Yes.
We have also gone through the postal circles mentioned above. We find that those cases of promotions were made in 2024, and vacancies were taken as of that year. In the instant case, the notification of PASA was issued in 12/6/2024. The examination was held on 2/3/2025. The results were declared on 27/3/2025, and thereafter promotions were effected from the post of postman, mail guard, MTS, PASA. Thus, this attempt of applicants shows they are beating around the bush, since as per their own admission, vacancies in the grade of postman, mail guard, MTS has arisen after promotion to PASA in the year 2025, which is after the calendar year of vacancy 2024, starting from 1/1/2024 to 31/12/2024. In the circumstances, the applicants are hardly any case of the.
So what is the wrong in it?
Minor. Firstly, the judgment cited is not at all applicable.
No, actually you
Actually,
satisfy us. The
Minor.
vacancy pertains to which year?
2024, minor.
no.
Minor.
So it must have been advertised that these are the vacancies.
Yes,
So accordingly, examination was held,
yes,
result was published,
yes,
and promotion was made.
yes.
Then what is your case?
Minor. There are just for better appreciation, I have just 1 minute, minor. There are
Take your own time, don't worry. We
minor.
are there.
There are 3 categories. Just a small chat.
Okay, you give it. He is getting.
No. There are 3 categories, minor.
Don't go fast.
No,
Be patient and go.
no,
Don't worry about it. Okay.
no. There are 3 categories, minor. From bottom to top, Gramin Daksevak 1 category. The promotional post is postman, multitasking staff, mail guard. Minor. The next promotion is postal assistant, sorting assistant, PSA.
The entry level is Gramin Dak Seva.
Gramin Daksevak. Okay. Right hand side, second box, minor. Exam was scheduled to be held on 21/7/2024. 21/7/2024.
From postman to post
Postman
assistant.
to postal assistant, sorting assistant. 21/7/2024. But due to the stay order of learned tribunal, the exam was my lord, held up, my lord. After vacation of stay order of Honorable Tribunal, exam was held on 22/3/2020. Advertisement sent, 2024 advertisement vacancy sent. My lord, result declared on fact box, my lord. Result declared on 27/3/2025 and 154 candidates promoted, my lord. Accordingly, postman multitasking staff mail guard vacancies 154 created, my lord. I am coming to chain vacancy. However, the exam, my lord, Gramin Daksevak to postman mail guard multitasking staff was held on 25/8/2024.
And why have you
Chronologically,
taken it to the top?
my lord,
You said that from Gramin.Sevak,
my lord,
they are to be promoted to postman.
my lord,
So, and that exam was held on 25/8/2020.
my lord,
And that result was published on 27/3/25.
my lord.
It should have been shown here in the that box here, not in the top. Because that goes to from postman to postal assistant.
No. Again, I am clarifying your lordship, my lord. Chronologically, the exam from postman multitasking staff to PASA was scheduled to be held on 21/7/2024. And the exam from GTS to postman multitasking staff was scheduled to be held on 25/8/2024. My lord, why such chronology, my lord? Because there is a circular for adding the current year vacancies in the postman multitasking staff and Mulgar, my lord. There is a circular, my lord. I am coming to that, my lord. Actually, if the exam of the postman MCS to postal assistant sorting assistant, just a clarifying, my lord.
The problem is you have read excess.
In short, my lord, just in brief.
You read it, prepare for. we are not able to-
You have read excess, you are not able to focus what is the exact issue. You are bringing so many things into it and on the
Take time and prepare properly. Put up this math.
focus the issue. What is the real issue? You are saying this, you are saying that.
Just-
So
Focus.
focus.
Item 6.
Item 6, your lordship. This is the petitioner challenges the order passed by the learned Central Administrative Tribunal in the review application and dismissing the same on the ground of limitation only. When this honorable court has been pleased to remand with the matter or directed because certain facts were never brought to the notice of the honorable tribunal either by the applicant or by this petitioner. That is the reason, lordship, a short dead side I have prepared.
No, show us the High Court's order and then the.
Lordship. High Court's order is at Annex 6, page 143.
Annex 6, sir.
143, running page 143.
In the case, certain facts had not been brought to the notice to the neither to tribunal, not in the High Court.
Yes.
Also, not brought to the notice of the High Court, nor it was enlightened to the High Tribunal. That's why my lord has remanded back for tribunal. Tribunal outright reject that it is a part of limitation because it is wrongly let it was filed. This is the order.
Let us read the
My lord,
High Court order.
page 145, your lordship. This writ petition, your lordship. There is writ petition has been filed by the Union of India and others challenging the order dated 27/6/2024 passed by the learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260 of 166 of 2022, in which, relying upon the decision of the Honorable High Court of Punjab and Haryana in the case of Punjab and Haryana, High Court of Punjab and Haryana, Chandigarh versus Jaswant Singh in LPA number 1852 of 2016, decided on 3/9/2019, it has been held that on his report to duty, obviously and axiomatically, the applicant's opposite party in this writ petition pay ought to have been fixed in the grade of SS, that is sorting assistant, from the date he was reverted to the cadre of sorting assistant till his restoration to the cadre of inspector in compliance of the order of the DA and AA, and that after completion of the period of punishment, he would be restored to the cadre of inspector as per the Government of India notification of official memorandum dated 7/2/1964. Such an order can be passed on his joining in the post of sorting assistant. Learned Counsel for the Union of India files a memo with a joining letter of the opposite party dated 8/2/2023 in the post of sorting assistant in Jharsuguda and submits that this fact of joining of the opposite party was neither brought to the notice of the learned Central Administrative Tribunal, Cuttack Bench, Cuttack, hereinafter the tribunal by the opposite party, nor by the petitioners, and it is very material document which ought to be considered by the tribunal in the interest of justice to arrive at a just conclusion, and therefore the petitioners intend to withdraw this writ petition to approach the learned tribunal by filing a review petition, bringing notice of the learned tribunal the joining letter dated 8/2/2023 of the opposite party and to argue to that effect. The memo is taken on record. In view of such submission, this writ petition is disposed of, giving liberty to the petitioners to approach the learned tribunal in accordance with law by filing review petition within 10 days hence, and the delay condonation application in filing the review petition shall be taken into account in keeping view of the section 14 of the Limitation Act. This was the order passed by the Honorable
Let us see
Honorable
what
High
the
Court.
tribunal says.
Now, Lordship, the petitioner within 8 days filed the review application online and it was registered within 14 days. It was filed within 8 days.
It's all right.
registered.
No, but order has been passed.
Now, Your Lordship, the order is annexed 2, that is order dated 21/7/2025, page 55. Annexed 2, page 55. Lordship, I'll go to the operating portion.
Paragraph 13%.
Mala. My lord, it comes around paragraph 11.
Paragraph 13 का even condoned.
Again, 13, right. Even condoning the delay for the period mentioned above, it goes without saying that the limitation from 9/7/2024 till 17/4/2025 still remains in force in absence of satisfactory explanation and on the face of the settled position of law that liberal approach is adopted in condoning the delay must specifically state the existence of sufficient cause for not filing the application in time is a condition precedent for exercising the discretionary power to condone the delay. The phrases liberal approach, justice-oriented approach, and cause for the advancement of substantial justice cannot be employed to defeat the law of limitation so as to allow stale matters, as a matter of fact, dead matters to be revived and reopened by taking act of discretion by granting by the statute. And further, the concept of such a liberal approach and justice-oriented approach and substantial justice cannot be employed to jettison the substantial law of limitation. In view of the discussions made above, the review application is not entertainable in the eye of law and the MOE is accordingly disposed of. As a consequence, RI is dismissed, no cost.
So we said that section 14 of the Limitation Act is to be taken into account because you approve this court without bringing into the notice of the. So you challenge the order dated 27/6/2024 in 2025 before this court.
My lord.
And
When the earlier writ petition was filed?
My lord, it was filed on 24/2/2025.
Okay.
And however, this writ petition for non-removal of defect, it was dismissed. Again, it was presented on 17/4/2025, and that writ petition was considered by this honorable court. And the important matter in this case, if my lord permits, by the date that I can explain, that this petitioner was reverted to the post of sorting assistant from the inspector.
We are not going on
we are
merits.
not going.
That's it.
Dismissed on question.
So it was almost 7 months delay on the part of this department to file the petition, writ application before the honorable court. I do consider that there is a delay, and the delay was for
Tribunal
this.
says the 14 benefit would be given only for that period. The writ was
Yes.
earlier to that, whatever the delay was, that
7 months delay.
Sufficient cause has not been shown. That's what
Madam.
the
But after order of this honorable court, it was filed within.
section 14 benefit you will get so far as that time consumed for the purpose of dependency
My lord.
disposal.
My lord.
But prior to that, what delay has occurred? What is the sufficient cause you have shown?
The delay, the sufficient cause was shown for the reason that
So as
This-
was where when the review, wherever you show,
Yeah, review petition, have you mentioned what is it?
why the delay?
yes, along with the review, we filed a MA for condonation of delay.
So what?
Your lordship, that is at page 201 to 205, Annex 8, your lordship.
Let us see that.
What are the substance?
Hmm. Paragraph 4, you'll also page 202.
Para four, huh?
My lord. After quoting the order of this Honorable Court at paragraph 3, we have stated that in view of the aforesaid orders of the Honorable High Court of Orissa, Cuttack, the review applicants have filed the review application before this Honorable Tribunal within the time period of 10 days as directed by the Honorable High Court.
Prior to filing the petition, what is the explanation?
Paragraph 6.
Again, it is humbly submitted that after receipt of the order dated 27/6/2024, passed by this Honorable Tribunal in OA number so and so, the review applicants had taken the proactive steps at their end by obtaining legal opinion from the branch secretary at Kolkata and adopting further course of action, making correspondences with the office of the learned DSJ Orissa High Court Cuttack and the concerned Central Government Council for preparation of and filing of the writ petition and vigorous efforts to get the matter listed before the Honorable High Court for adjudication. That it's humbly submitted that delay in filing of the review application before the Honorable Tribunal has taken place due to the time consumed during the course of necessary departmental paraphernalia, along with interdepartmental correspondences made towards preparation and filing of the writ petition. And the matter is being sub judice before the Honorable High Court of Orissa Cuttack. As such, the delay is neither deliberate nor intentional, and it was beyond the control of review applicants, and the same was required to be condoned. Further, the review applicants had filed another writ petition before the Honorable High Court.
It has been considered by the learned tribunal.
Your Lordship, that has been considered paragraph 13.
Para 30.
Lordship, annexed 2, that my Lord was seeing, page 55.
No, paragraph 13, there is nothing. Your
But-
opinion thought for.
But it has never mentioned in the order. It is written that this period in filing the writ petition was never sufficiently explained.
No, ତାକୁ exclude କରିକିନି ମଧ୍ୟ ସେ କହୁଛନ୍ତି ଯୋଉଟା ଯୋଉଟା ଆପଣ ଅର୍ଡରଟା ପ୍ରଥମ ଅର୍ଡରଟାକୁ ଯୋଉ ଚ୍ୟାଲେଞ୍ଜ କଲେ
Again,
ତାପରେ obviously you challenge the order dated 27/6/2024 before this court in 2025.
my
In
Lord,
read petition there is no question of limitation,
my Lord.
but since you there
Yes,
for the
yes,
order
yes,
of
my
this
Lord.
court that problem arose. But you have stated that after the order was passed on 27/6/2024, you sought for the advice. Look, this writ petition has been filed by the Union of India and others challenging the order dated 27/6/2024, so also 27/6/2024, passed in by the Land Central Administrative Tribunal, EOA number so and so, theta OA is selected, and the order dated 21/7/2025, passed by the Land Central Administrative Tribunal in RA number
260/11/2025.
RA numberটা লেখা হয়েছে ঠিক RA numberটা কোন লেখা হয়েছে
Paragraph 1, your Lordship. The cost title.
মানে cost title
Cost title as well as synopsis.
Annexure 7 নে কোড লেখা হয়েছে on
And my Lord, cost title as well as synopsis. Both places I mentioned that.
order লে 20 RA এর order টা
Again, there is page 55, annexed 2.
55
Annexed 2.
हाँ RA number 260 so on so. It appears that the petitioners approached this court in WTC number 12302 of 2025, challenging the aforesaid order dated 27/6/2025, passed by the Land Central Administrative Tribunal. This court after hearing the land counsel for the petitioners, and the contention of the land counsel for the petition to withdraw the petition to oppose the Central Administrative Tribunal by filing a review petition bringing to the notice of the Land Tribunal the joining letter of the opposite party dated 8/2/2023, disposed of the writ petition, giving liberty to the petitioner to approach the tribunal in accordance with law within a period of 10 days. And it was specifically observed that the delay condonation application in filing the review petition shall be taken into account, keeping in view Section 14 of the Limitation Act. After the writ petition was disposed of on 2/7/2025, the review petition was filed by the petitioners on 9/7/2025 before the Central Administrative Tribunal, which was registered as RN number so and so. However, the London Tribunal has been pleased to hold as follows, quote paragraph number 13 and 14 also. The London Counsel for the petitioner, subparagraph, drew the attention of this court to paragraph number, वो paragraph में लिखा है जो ये advice नले ये नले उड़ा दी ये मेरे लिख दी
That is paragraph 6.
Along with the RA, one miscellaneous application was filed, that is MA number 322 of 2025 for condonation of delay, wherein it is stated as follows, quote paragraph number 6 and 7. The contention of the Land Counsel for the petitioner submits is that without taking into account the specific averments taken in the miscellaneous application regarding the belated filing of the review petition, the impugned order was passed on 21/7/2025, which is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice on the sole opposite party within a week, and matter will be listed after sworn. Yes, no.
You also filed a IA also because the contempt proceeding is pending for the, that is 13470 of 2025.
IA number 13470 2025. There is an application for. No, what is the contempt petition number?
Not that is in paragraph 3. This CP number.
Stay of operation of the so and so. Hello? It is stated in paragraph number 3 of the interim application that the opposite party has filed a contempt application before the London Central Administrative Tribunal, which has been registered as CP number 260/81 of 2024, which is posted to 21/8/2025. Stop. Since we have issued notice in this petition, the London Tribunal shall not proceed in the contempt petition until further orders. Yes.
Item 7.
Item 7, Lordship, I'm praying for a short adjournment, my lord.
Mr. Mahanti,
My lord, I'm praying for a short adjournment, my lord. I'm in VC, my lord.
when you want.
Lordship, in the first week of September would be much better, your lordship.
In this matter, I have instruction to appear on behalf of the opposite parties.
Which opposite party?
ICC.
File your
I will file my.
Wakalatnama. File and it will automatically be. Yes. The Learned Counsel for the petitioner seeks for an adjournment on Nadirium. So and so submits that he has instruction to appear for opposite party number 2, 3, and 4, ICCI Bank. And he will file his Wakalatnama within a week. Matter will be listed in the week commencing from such and such date. In case the Learned Counsel enters appearance for the opposite party number 2 and 3, the name of the Learned Counsel shall be reflected in the cause list. Yes, next.
Item 8.
May please. But, I mean, in instruction, though the bank has not communicated any rating, but my instruction is that e-auction cell, though that was floated, but that has not been, nobody is
You
participating.
file an affidavit to that effect. File an affidavit that it has not been successful.
May I pray your lordship, subject to your lordship's approval, but because they have not communicated any written,
You can, RTI, you say that e-auction sale notice was issued,
yes, madam.
but it has become unsuccessful.
Yes, madam.
So please file, we will not, you see, once this,
I vowed on, madam.
just file that affidavit.
I have already communicated by 2 email. The difficulty is that our original bank has been amalgamated to the Odisha Gaming Bank.
Whatever.
That has been
See, in the first order, 1885 order, we have already indicated that you have an alternative.
Only what I
Still, we are
pray,
entertaining in the sympathetical ground. You have been taking adjournment.
because
Once it has been become unsuccessful, now we are referring the cases to mediation also. But for that, we must know that at least that that has become unsuccessful, so that the bank can negotiate with you in the mediation proceeding also.
my non friend is also appearing in this case. They can also take instructions in this.
Come to order dated 1880.
I'm aware of that, my
You
lord.
say tomorrow it is settled.
Well,
You see, para 3, second para.
It is your case and you know that the e-auction has become unsuccessful.
next week, so
Here to put you upon.
next.
Look, the Learned Counsel for the petitioner submit that the e-auction sale notice, which was issued on 30/7/2025 by annexure 3. The e-auction sale pursuant to notice dated so on has become unsuccessful. And he may be given some time so that he will file an affidavit in that respect. Put up this matter. It's very important. Yes.
Both, my lord. 8, 8, 9.
8 or 9, same. 8 and 9. So, yes.
Item 10.
Mr. Vishwa. Soumya Jyoti Vishwa.
May I please, Your Lordship? Your Lordship, in this instant matter, the petitioner has availed the loan from the opposite party. The loan amount was of rupees 18,33,816 rupees. They entered into an agreement on 24/12/2023. The loan installment started from 2024, and for an entire year, the petitioner was diligently paying the EMI amount. The EMI amount was 54,950 rupees. The entire installment has to be paid within a period of 4 years. After a year, due to some unforeseen financial hardships, the petitioner could not pay the EMI amount, and for that reason, the opposite party, without giving any notice to the petitioner, seized the vehicle, that is the truck of the petitioner, which was already loaded with iron ore, which was not, and the petitioner was not the owner of the iron ore, a third party was, seized the vehicle, and even after the seizure did not provide any kind of notice to the petitioner. The petitioner tried to consult the opposite party
When the seizure was made,
pardon me,
when the seizure was made,
in 7th of 2000 in 5/7/2025. The seizure was made on 5/7/2025. The petitioner tried to reason with the opposite party that he is ready and willing to pay off all the pending EMI amount and let the vehicle be released in his favor.
Where have you said that it was picked up without notice?
Yeah, I've mentioned it in the petition, Your Lordship.
Where is that?
which paragraph?
Your Lordship, in page number 9, I have mentioned that the
Read it.
SRPC in the
Read it.
grounds I mentioned that no notice was provided, even though there is a specific provision under the SRPC Act under section 13(2) that a notice has to be provided to the borrower before any kind of action is to be executed before against the borrower. Your Lordship, now my contention is that I have not received any kind of notice from the opposite party. Your Lordship, right now I'm facing two problems. First, in general, a writ petition against an NBFC is not maintainable. However, this honorable court and multiple courts across, on multiple high courts across country has recognized the fact that when two parties or even the borrower is willing and ready to pay the EMI amount or the default amount, even if the writ is not maintainable, the same can be disposed of by
There is a direct judgment of Supreme Court. Where is that judgment? Which says that the bank and financial institution cannot pick up the vehicle if the installment is defaulted.
Your
Where is that
Lord-
judgment? Have that judgment with you.
Magma leasing, Rajesh Tiwari.
Why are you doing all this thing? You pick
No,
up
it
vehicle.
says, it says that if there is a default,
You can pick
financial-
up without
financial has
notice,
right
without
to
anything.
repossession.
Park somewhere you take it out.
But we do not know. This first time is coming, let him submit a copy to this, and it says,
Grand counsel for the so submit that he has instruction to appear for.
I am filing Vakarat.
Your Lordship, I have a limited prayer. I have also filed an NDA.
Let him take
Let us-
instruction.
let
He
us
cannot
take-
accept.
And it
and,
may not be surface act,
Usually
it's a
the-
vehicle release matter.
Just take instruction and file. Look, Mr. Ramchandra Panigahi, Land Council and his associate file power for the opposite party. It's taken on record. Let a copy of the writ petition be served in course of the day. On the Land Council for the opposite party will obtain instruction on the matter, foot of this matter.
Your Lordship, can I just make one humble submission? I completely bow down, but Your Lordship, my only concern is when we spoke with the opposite party, they threatened us that they will issue an auction notice. And once the auction notice is issued, it will be very difficult on my
No, the
part. to
real picture may
establish the
come
detail.
after the his takes instruction. We cannot just accept everything, whatever he was stated in the writ
Let us
petition.
understand
Maybe
what is that.
there may be some other things which might not have been reflected in the writ petition. Yes, next.
Obliging.
Much obliged.
Item number 11.
Item
Defect
11.
not removed. So there is on the 2 weeks time granted to remove the defect, failing which it will stand medically dismissed without further reference. Yes, next.
Item 12.
12, I may be permitted on behalf of Mr. Jagman.
Yes.
So there is a noting for notice, noting Miller, notice return answer from the opposite part number 9 with postal remark insufficient of address.
Good लिखा है।
Lordship, item 12 in the middle.
It is returned from answered from opposite party number 9.
9 with postal remark insufficient of address.
Ah.
Lordship may be given 10 days time. I will provide the sufficient address.
May submit.
Opposite party number 10 refused to accept
Accept.
due to non-entry of the residential address.
I will provide you, Lordship. I will.
And you पूरा noting the Lordship में clear से OP7 it has been written Lord. AD from OP7 received after service made on an employee or staff named Sanjay Kumar Pradhan on behalf of OP7, but he is not a party to this brief. Notice returned answered from 9 with a remark insufficient address.
That he will do, sir.
That is to be treated sufficient. Insufficient address, he is to take steps.
I will.
Yeah. Then,
Time to your Lordship may be given 10 days time. I will be when the proper address will
ଆଜ୍ଞା ମୁଁ ଟିକେ କହିବି OP 10 ଟା alert ସେ refuse କଲେ OP 10 then sir
এটা sufficient হবো
ଆଜ୍ଞା sufficient 8
তারপরে
and 11 with a tracking report
এটা আসছে tracking report নাই but tracking report আসছে so that item has been delivered so it is to be sufficient তারপরে 5 received showing 5 extra copies of the 1 by 1 লেখুন it has been pointed out by the registry that AD from opposite party number 7 received after service made on an employee oblique staff named Sanjay Kumar Pradhan on behalf of opposite party number 7. But he is not a party in this case. Land counsel for the petitioner 6 time, 1 week time to take steps, take fresh step for service of notice on opposite party number 7. Unutilized copy, acha oita solve hoi jeichi pore chhadi. It is further pointed out that notice written answer from opposite party number 9 with postal remark insufficient address. Land counsel for the petitioner 6 time, 1 week time to furnish the correct address of the opposite party number 9 along with fresh requisites, non-utilized copy be utilized. Then it is for a short paragraph like that. So far the notice from opposite party number 10 as written with postal requisites with postal remark addressee refused due to non-entry of the resident address. This is to be held sufficient. Then AD not received from opposite party number 8 and 11 but tracking reports at flag P and Q respectively so that item has been delivered to the address. So notice on OP number 8 and 11 held to be sufficient. So those are sufficient, 8 11 sufficient and 9 से step nebe. So also 7 step. Next.
Milord, may I pray? I'm appearing for the private opposite party number 6 now. This is a matter relating to promotion by way of selection. The order of the honorable CAT is under challenge, Your Lordship. The last order, the order where the interim order was passed, Your Lordship may kindly say for a second, Your Lordship. Your Lordship directed that the matter will be disposed of at the stage of admission.
But notice is not sufficient.
Date what
1 week ভিতরে step নেবে তারপরে জীব আসিব it's next.
See, opposite party number 1 to 5 but file the counter but not serve the copy. You see.
Aja, the Land Council for the petitioner submits that though counter affidavit has been filed by opposite party number 1 to 5. Union of India ପାଇଁ କିଏ ଅଛନ୍ତି? These are all Union of India. 1 to 5. Railway. So, Mr. Quad Gole. Mr. Pari, unmute, please unmute yourself.
Kind of good.
Item 12. You are the opposite party number 1 to 5.
Yes, ma'am.
Railways. You have filed your counter affidavit, but copy has not been served on the Land Council for the petitioner. So please serve the copy.
Yes, we'll serve.
be served on me.
Acha, and also on opposite party number 6. The Land Council for the petitioner, so also the Land Council for the opposite party number 6 submits that even though the Union of India and East Coast Railways filed the counter affidavit, but the copies have not been served. Mr. Pari, Deputy Solicitor General, submit that the copies will be served by next week, both on the Land Council for the petitioner as well as opposite party number 6. Date fix up for the yes, next.
In September.
Yeah.
In September.
September end week was kind of say speed post file kariyo 1 week tapare jibo as. Yes. Next.
Item 13.
13.
There is a delay.
What is this criminal appeal for?
Life conviction 302.
302.
30.
How much delay is there? 583 days. Condone for those. IN numbers 1 shows an application for condonation of delay. The stamp reporter has pointed out that there is delay 583 days. After hearing the land counsel for both the parties and going through the averments taken in the interim application, and since it's a case where the petitioner has been sentenced to imprisonment for life, we are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit call for the trial court record. Yes.
Item 14.
Filing the appeal mail.
What is this criminal appeal for?
302 conviction on
Life imprisonment. And how much delay is there?
delay is
849 days. Same order for them. Delay condoned.
LCR is available.
Oh. I would a case, connected case.
Aye.
It appears that in the connected case, that is CR number 112 of 2022, the trial court record photocopy is available. Therefore, there is no need to call for the trial court record once again. The matter will be listed along with, henceforth the matter will be listed along with CR number 112 of 2020. Yes, next.
Date.
Any
date?
Date कौन पे हो? अपन फाइल करचेंदी किसी interim application for bail.
Yes.
It is okay. The you have supplied the deposition copies.
Copy.
Paper book is ready.
Paper book ready. अच्छा, then the same judgment both of you are found guilty.
Yes, ma'am.
Let us see that there are two accused, and what happened?
Another co-convict has been released on bail.
Yes. We found this judgment which you have annexed. That is at annexure 1. There are two accused persons who are facing trial. One is Jagat Jewel, the other is Mitra alias Montu. This appeal has been filed by Jagat.
Yes, sir. Another 1 and 12 was filed by Pavitra alias Montu.
Okay, ma'am. Are again the same
judgment?
All right.
Number 10.
The
1 and 12.
so you in that 112, what he says, Mr. Mahanti, in that 112, the deposition copies have been supplied and that accused has been released on bail. So you verify whether that deposition.
Some other day I will verify that.
So it will first we comment on past one. Land and Council for the, you are the counsel in that case?
Yes, sir.
Land and Council submits that in CRLA number 112 of 2022, in which the appellant is one Pavitra alias Montu Jewel, deposition copies have been supplied to the Land and Council for the state, and in the state case, the appellant Pavitra alias Montu Jewel has been released on bail. The Land Council for the state seeks for an adjournment to verify regarding the availability of the deposition copies in the records of CRLN number 112 of 2022. All right. It is the 1st of September 2025. Yes.
Maybe one thing, if my lord that is not available, you can also take a paper book.
If paper book is there, you will take.
All right. You have not received the paper book.
No. Today it's a place.
Copy of the the copy of the paper book will be supplied to the Land and Council for the state. Yes.
Where I know. Item number 13. Yes. Item number 13. It is appeal under section 372 of the CRPC. We acquitted the.
But they said that there is convictable.
No. That's for us. To care of high practice person.
Just a minute. I do not award death sentence, but the imprisonment for life or ठीक है इसको कौन हला अपन इटा कौन पे फाइल कर जंदी
Appeal against acquittal.
कितने जनो appellant थे लगी
5 जन.
So,
conflict ହେଇଛି
ତିନି ଜଣ prefer କରିଛନ୍ତି appeal. That
so you have, acha,
I was provided in my
it's
certificate.
all right. তাহলে সেটা কাটি দিଅନ୍ତୁ ସେ ଯୋଉ ଇଏଟାକୁ ଲେଖନ୍ତୁ first item ରେ CRL number 965 of 2025. IN number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is a delay of 583 days in filing this criminal appeal, which has challenged the influence judgment and order dated 30/10/2023, passed by the Land Additional Session Judge Kodala, Ganjam, in ST case number 100 of 2020, bracket so and so, in acquitting the respondents number 2, Santosh Swai alias Aryam, and respondent number 3, Ravindra Swai, of the charges under section 302/34 of the Indian Penalty. Issue notice on the question of limitation. Land Council for the petition appellant shall file the requisites for issuance of notice on respondent number 2 and or speed post requisites for the proof of delivery. Within a week you file, right?
State has filed appeal, no.
File appeal. I have given the number that CRL number 91 of 2004. The other accused person, 3 accused person filed 3 separate appeal.
No. Whether state has filed appeal against the acquittal.
No, man.
Like the Land Council for the states are also obtain instruction in the meantime as to whether the state intends to file any appeal challenging the acquittal of the respondents number 2 and 3 by the Land Trial Court. Hello? So, wrong here for the number data. Second conviction ଅଛି ତ 14 number ଟା ଠିକ ଅଛି ତାପରେ
My lord, I'm a pardon. My lord, not from the password item.
ହଁ
Item
number item
item 3 one.
3 yes
May I pray, my lord? WPC number 13139, that is sub item, may be taken off first because the benefit of that order extended to the opposite party in the first item.
who is appearing for the Union of India.
In that case,
WPC number 20569, Your Lordship,
For the Union of India.
for the Union of India.
But Mr. Parhi, Mr. Parhi,
You are appearing in one matter.
In one,
The other matter,
the other matter.
you want to argue the other matter.
take the Solicitor General is talking with somebody else.
Hey, Mr. Paddy,
Mr.
item 3, who is appearing?
Yes, my lord.
ସେଠି ଗୋଟେ ବକ୍ସ ଲଗେଇ ଦିଅନ୍ତୁ ଆପଣ ମ୍ୟୁଟ କରିଦଉଛନ୍ତି ନା ସେଠି ଗୋଟେ ବକ୍ସ ଲଗେଇ ଦିଅନ୍ତୁ କୋର୍ଟରେ ଆସିଲେ ଯେମିତି ଜାଣିପାରିବେ ତାପରେ ଅନମ୍ୟୁଟ କରିବେ ସେଠି ଆପଣ ଗପୁଛନ୍ତି you are to argue this item number 3 WPC number 13139 of 2024. The Land Council for the opposite party is present. Are you ready?
my lord,
Give some time. I'm not ready, my lord.
instruction. Your lordship,
I'm not
my lord's order is 97, my lord. Because this case is covered to my lord's judgment.
Just he is not ready. What can be done? We take up something.
Next week, let's make it. Other citizen.
Mr. Rautra filed that in similar case in WPC number 21713 of 24, the judgment has been pronounced by this court on 2/7/25. And he says that the issue is involved in the present writ petition is covered by the decision rendered in that WPC. So copy of the judgment has already been handed over to
Yes,
you.
yes, my lord. They have honored. Also, give only
Just,
three,
examine
3
and
days
tell
time.
us
I have to go through.
whether
3 days.
it is covered by that decision or not. That much you want to say. So perhaps you have not studied, so we are adjourning this matter along with the connected matter and tell us that whether it covers or not.
Yes, yes,
Right.
my- yes.
Judgment, Your Lordship, has also been provided in the first sub-item.
The Learning Council WPC number 13139 of 2024. The Mr. Parhi appearing Deputy Solicitor General along with Mr. D. Goshai, Central Government Council tha?
Again, Central Council, CGC. And there are 2 different cases, 2 different councils. One is Ashutosh Mohanty, another.
It's all right. Submit that he has received the copy of the judgment pronounced in WPC number 21713 of 2024, and he may be given some further time to examine whether the said judgment covers the issue involved in this case or not. Put up this matter.
What about in the first matter? Is he covered?
Same.
The first matter is not covered. I had, on the last occasion, I had
See.
given a memo.
Yes. ଆପଣ ଅର୍ଡରଟା ଖାଲି ପାସ୍ କରିବେ ଏଥିରେ 13139 ତାକୁ ଲେଖିଦେବେ ୱିଥ୍ ଆସିବ ଏଇ ଯୋଉ କଣ ଆର ମ୍ୟାଟରଟା ସାଙ୍ଗରେ 20569 ହେଇଗଲା।
Item 16.
15 କଣ ଡାକିଲେନି?
Item 15.
But between Vijaya Bank and State Bank, Lord, I have caught minute. My learned friend has come. I have intimated him. Lord, he has come.
Mr. Gajendra, you are there.
My problem is that now Vijaya Bank, I told my friend, Vijaya Bank is no more in existence. It has merged with Bank of Baroda. I don't know why the
No,
petition.
because you appeared for the Vijaya Bank
Yes, ma'am.
and I think
I have no, now I am in
so
absence
you,
of.
you filed the Wakalatnama also, I think.
No, yes, I
Yes.
was there. I was
No,
confessed.
that's all right, but that is why we thought it proper that in your presence.
Yes,
we can
I'm
move
obliged.
correctly.
I'm obliged.
So now the Vijaya Bank is not in existence. It
Not
has
in existence. Merged with the Bank of Baroda. I don't know why petition so long as conversant with the bank activity should have included them as party by Bank of Baroda.
Bank of Baroda he has impleted it. You have not impleted.
Not yet impleted.
Then in view of the statement made, you have to implement and notice has to go.
Lord, the statement I think is falling for the first time today. And it was never.
Vijaya Bank is opposite party number.
Vijaya Bank was not the first approach this honorable court.
It's all right.
Yes.
No more existence.
Existence ନାହିଁ ବର୍ତ୍ତମାନ ସେ ତାର ଇଏ ସବୁ ଏମାନେ
What I humbly submit, Palat, let me just bear with you for 1 minute. When there is a direction by this honorable court to State Bank of India and Vijaya Bank to have a committee formed.
Yes.
And the committee has to sit across and decide as to in fact who is to be paid the amount and how the land to be sold to me.
Vijaya Bank
But then Vijaya Bank, that's just one minute.
merger
Merged with the Bank of Baroda.
Bank of Baroda.
Then Vijaya Bank had 2 meetings. And thereafter they should have come forward, Malad, 2 meetings 5-6 years back.
Thereafter the amalgamation.
Well, thereafter it never proceeded any further.
Submit that he was appearing for Vijaya Bank with opposite party number 3 and 4 in this writ petition. However, in the meantime, Vijaya Bank has merged with Bank of Baroda. Mr. Das Land Council, senior advocate appearing for the petitioner, seeks time to amend the cause title, including the Bank of Baroda as a party, so that notice can be issued. Put up this matter. Conventions from 1st of September 2025. If in the meantime any interim application has been presented by the counsel for the petitioner, the same shall be placed on record. The name of Mr. Sarath Kumar Gajendra and senior advocate shall not be, and his associates shall not be reflected in the cause list henceforth. Yes.
My lord, my presence may be required.
हाँ.
You're for State Bank of
Mr. Sadangi, S. Sadangi, no?
Yes, sir.
S. Sadangi, Land Counsel for the State Bank of
State
India
Bank.
is present. Okay. Yes, next.
I have in fact the claim against the State Bank only.
ନାଇଁ ଆପଣ କେଇଟା କେବେଠୁ ହବନି ସେ ଆପଣ ନବା କଥା ନା ଆପଣ କେସ୍ ଫାଇଲ କରୁଛନ୍ତି ସିଏ ବି କିଛି ଜଣୁନାହାନ୍ତି ଆପଣ ବି କିଛି କରୁନାହାନ୍ତି.
Last year I had mentioned that.
Item 16.
Item 16, we have the order 48/2025.
48. Arts one show, okay.
It appears minus balance level and IA.
Yeah,
3704 for 2025. Of course, it indicates per time, but they should have served a copy on us so that we could have known it earlier. You have moved an application without serving a copy to us.
This extension of time you have filed.
Yes, yes.
Why are you not serving copy?
But today I will.
IA number देखो 3704 of 2025. This interim application has been filed by State of Orissa.
They have to comply, extension to
Just a
comply.
minute. Seeking for 8 weeks time to enable the state to complete the required process and to produce the compliance report before this court for effective adjudication of the appeal. Stop. Mr. Rothol and senior advocate appearing for
I'm appearing for
the
respondents.
party number. अपन कहाँ पे appear करूँ?
Sir, move appeal to see
1 to 24.
1 to 26. No, 1 to
1 to 24.
For the respondent number 1 to 24. And Mr. Purohit, have you received the copy?
No, ma'am.
It's for the university.
And so also Mr. Sisir Kumar Purohit, Land Council, appearing for respondent number 25 and 26, Sambalpur University, submits that they have not been served with a copy of the interim application. Stop. The Land Council for the state served the copy of the interim application in court today to the Mr. Rothol and senior advocates, also Mr. Purohit, and this thing for adjournment. Next week, Rakhi Dhawan?
Sir, 7 time also.
What's
It takes
up?
time for
Because
development.
we had directed that in 4/8/2025 to form a policy.
Because para 5 will indicate it is required.
ଆପଣ ଏଇ interim application କେବେ file କଲେ? 19/8
Interdepartmental consultation.
On the
is there.
last order, your lordship directed that you get instruction whether
Policy can be.
on that, in response to that, they have filed this IA. Seeking further
ये
time.
तो पूजा करू पड़ेगा और 8 सप्ताह माइलसन माने पूजा करू
Puja agadu hele, it might be a puja gift. If at all it is.
It is a para because the regularization of contracts is the.
अच्छा हमें रखी छोटे डेट ये डेट को यदि कुछ असुविधा है
Then we'll.
तो let us keep it on 24th of September है
Yes.
We have take care number.
Exactly.
Because the interdepartmental consultancy required by the GA finance,
Pending, see, the
the financial, serious financial implication is there. Financial, that requires some budgetary provision. That's why.
this matter is pending since 2020.
And that's why we are concerned, that is.
And university is also aggrieved because you are not giving appointment.
No,
They are
university
also.
has, university has committed the mistake, that's an burden shifted. to
Because
state.
your secretary, your
Company
chief
that-
secretary was there in that meeting.
But that's.
That is the reason we took a view. Anyway,
Some financial implications, that's why.
24th of
Reasonable
September
time.
2020.
24th September you do it.
The Learning Council for the State shall apprise this court about the development in the matter. है ना? 24.
My lords may kindly give that as the last chance because
that-
otherwise they will be going on taking it from time to time.
ମାଗିଛନ୍ତି ବହୁତ time.
ବହୁତ time ମାଗି ଆମେ ତ କଟ୍ ଛଟ୍ କରିକି ମିଷ୍ଟର ପୁରୋହିତ କହିଲେ
No more time, my lords.
ପୂଜା ଅଛି ବୋଲି ସେଇଥିପାଇଁ ଆମେ ସେ ରଖିଲୁ ତେଣୁ ଆସୁ 24 ତାରିଖ ଦିନ
ଟିକେ ପ୍ରେସର ହବ ରହିଲେ।
Okay.